Doesn't that involve an intangible?
It's a very imprecise opportunity is different than Brown's. Brown actually.
I'm talking about the whole concept of equal educational opportunity.
Right. Well,
which is a progeny of Brown. That's ongoing.
I would say, Your Honor, that has been difficult because of political will, not because of difficulty in standards. Brown was quite easy.
Don't we read a positive qualitative standard into the word equally?
I'm sorry, Your Honor.
When we talk about equal education, we imply a positive qualitative factor. We don't say equally poor, certainly, and downgrade a superior system. We upgrade. It's equally good. So we have that. It seems to me it's the same kind of implication here. We're not going to talk about having free public schools unless we're implying that they're going to meet some positive standard of quality.
Well, but only as a comparator, Your Honor. That's the best answer I can give you, is that equal educational opportunity is measured and then compared to one another, not for purposes of what is this child's educational opportunity and is it enough in and of itself, not compared to anybody else, but as a constitutional matter. That, I believe, given our text and our history, there simply is not a right to. And I think what the plaintiffs rely on to make up historically and textually this right is like Moore in many, many ways. It's actually the difference, as Moore said, the difference between a laudable history of statutory provisions. The plaintiffs have several of them that go back to the Ludlow Code and to 1909's Code and to 10-4A. The difference between that laudable history and an affirmative obligation. The court has said it's especially hesitant to read into the Constitution unenumerated affirmative governmental obligations. That's what the court would be doing by determining that there is an affirmative qualitative standard to measure the education by, rather than an equality component. It looks to, in Moore, the court said that it would reject the lowest common denominator approach. I think the colloquy we've just been having is just that. Isn't there a lowest common denominator approach implicit in our Constitution? The court said no, that would be an act of judicial conjecture and not constitutional adjudication. Where does the plaintiff get these standards? That's the question for Geisler analysis, and that's the question for the plaintiffs. And the answer is they've been inconsistent in shifting about where you get it from. I don't say that pejoratively. I say that to demonstrate that there is, as Judge Shortle said, a very slim reed on which to try to base an affirmative qualitative right to any qualitative measure of education. It doesn't come from suitable. That's a statutory term, 10-4A. If that's their claim, well then that's a State Board of Education claim, and there's an administrative process for that. It doesn't come from appropriate. It doesn't come from, as we've discussed, appropriate modifies legislation. It doesn't come from good education. Good education in the Ludlow Code was not an admonition to the government, it was an admonition to parents on penalty of 20 shillings if they didn't educate their children. In fact, the obligation to pay for the education was on the parents in the Ludlow Code, not on the state. So that history really doesn't get, or on the inhabitants of the community. So the question is, what's the precise language under this court's cases? And as I say, it's little wonder that Judge Shortle couldn't cobble together enough to make this a constitutional right. And in fact, it would be very ironic if at the Constitutional Convention of 1965, which was called to correct undemocratic, the undemocratic makeup of our legislature after Reynolds versus Sims, if at that Constitutional Convention a provision went in that would arrogate to the least democratic branch the ability to measure and enforce a quality of educational legislation. And the holdings of this court under the Geisler analysis similarly do not support. This court has historically referred to the fundamental right as the right to free public education, and read through the lens of the Equal Protection Clause, the right to a substantially equal educational opportunity. That's Horton, Campbell, Savage, Broadley, Sheff. Never has the court even connoted that there's a qualitative standard. In fact, in Broadley, the holding was to the contrary. When in the one invitation to the court to make a qualitative, indicate that there's some qualitative component to Article 8, Section 1, that was rejected. The sister states, I will mention briefly, the best reason not to follow the sister states, and that it's not relevant to, for the most part, to a Geisler analysis, is that the delegates at the 1965 convention didn't follow the sister states. There was language put, they indicated we're the last ones to have an educational article, and they didn't copy it from other states. And nor did they add any qualitative language, and they did in the very next section. Article 8, Section 2 has the term excellence in that section. They knew how to do it. They knew other states had did it and had done it, and chose not to. The decisions of all the other states are based on their own unique language and their own unique history. And it's not correct to indicate, as the amici do, and as the plaintiffs do, that we would be the only state without a qualitative component. That's not true. A number of the states have held that their educational articles are non-justiciable, and therefore there is no judicially enforceable qualitative component. And I want to make sure that I've completed my thought about Sheff. If I'm repeating myself, I apologize, but Sheff is very different. Sheff does not indicate that and give license to the court to always second guess whether there's appropriate legislation, in the sense that, does the legislation do enough? Does it, should the legislation be doing other things? Sheff and Horton held that legislation is always inappropriate if it violates some other constitutional provision. I should mention 10-4A and 10-4B briefly. This is those statutes and the administrative mechanism in 10-4B manifests quite clearly that what the legislature has done in setting standards of suitability by appropriate legislation is in fact appropriate legislation. It has been up to the legislature under the second sentence of Article 8, Section 1, to determine how to implement the educational article. And one of the ways they've done so is to set a qualitative standard administratively. The plaintiffs have used that and imported that into their complaint as a matter of constitutional law. Again, broadly says that's not appropriate, that's not correct. This informs both the merits and our justiciability claims, which is to say that on the merits, there is no textual basis in our Constitution for using that statutory term as the basis of a constitutional cause of action. And on justiciability, as I mentioned, it's an example of the General Assembly appropriately carrying out its function to set the standards of education. And the plaintiffs cannot, and I don't believe they do,